most people don't quite understand land claims versus like Aboriginal title. And it's important that those are very distinguished. So what the land claim settlement that Madawaska just went through was a specific land claim. And that's a policy that was put in place by the federal government. So you have comprehensive land claims and specific land claims. So specific land claims are really about the government doing something wrong or not doing something that they should have done. And that's a specific land claim. So in the case of Madawaska, what happened was back 230 years ago, the province of New Brunswick set aside 4,000 acres of land for reserve for Madawaska. And over a span of about 80 years, that land was alienated unlawfully. And that's where the breach happened. So Canada was, sorry, not Canada, but New Brunswick, or the Crown, was supposed to protect that land that was set aside, and they didn't. Settlers were encroaching and squatting on the land, and the government issued them land grants. And so in that process, Madawaska lost over 3,000 acres of land illegally. So this was a claim that I had brought forward almost over 25 years ago, actually. So that is a specific claim, and that's a specific claim because there was an obligation, a lawful obligation on the part of the Crown to protect that from being taken away. And so, of course, this happened before Canada was a country. It was New Brunswick, but that responsibility got transferred over to Canada when Canada did become a country in 1867. So even though the breach happened before Canada was a country, they were responsible. And just so you know, New Brunswick wanted nothing to do with this, had no part in it, even though they were the ones responsible for setting aside the land and taking it away. So that is a specific land claim. Now, a comprehensive land claim is more of like a modern treaty process. And that was kind of put into place a long time ago when, I think in the 80s, 70s or 80s. And that was really to try and deal with areas that hadn't actually gone through any land cession treaties. And so a lot of that is it's out in British Columbia, and it's here as well. So it's more of a modern treaty making process, along with self-government, a self-determination. So a self-government agreement, which would mean that a First Nation can completely opt out of the Indian Act and be self-governing, but then there's a whole set of rules around that. And you know, even though everybody hates the Indian Act, there are some protections in there for First Nations. So land claims, there's two kinds. There's comprehensive and specific, which I just explained. And then you have Aboriginal title. Now, they kind of seem to go together, because a comprehensive land claim would be in an area where the land was never ceded. But if the land was never ceded, who owns the land, right? So as we all know, in Canadian law, the Crown owns all the land. Even if you bought your piece of property in town and you have you have your deed, your fee simple, what have you, you don't actually own it. You have a bundle of rights to that land. So if the government needs it, you're out of there. So you know, when you're in law school and you hear this, you're like, the Crown owns all land. That's just like, wow. Well, what about Aboriginal people who didn't give up their land, or who weren't conquered, or who weren't, and so that's where Aboriginal title comes in. So there's like an underlying ownership to the land. And that is something that the Wolastoqey, that's what we did back in October of 2019. We filed an Aboriginal title claim. So we're basically saying we never gave it up. So the underlying title belongs to us. So that's different from another, like a specific land claim, which really deals with, I mean, they call it specific because that's exactly what it is. It's specific to an obligation, a legal obligation. So, and then comprehensive claims is really more about modern treaties. And that's a scary term, because a lot of people are thinking, oh, no, our treaties are fine. Yes, our peace and friendship treaties are fine, and we don't want to get rid of our peace and friendship treaties. But out west, further out west, they didn't even have any treaties. So it's important to sort of distinguish that, because when people hear, oh, you know, the Wilstaway, they just filed a big land claim. It's actually a title claim. It's not a land claim. So we're looking for the underlying recognition that that title belongs to the people who were originally here and never gave it up, whereas a land claim is very specific. So just to give you, like I just briefly gave you a bit of information about the specific claim that we filed, and what's amazing about that is that it's the history of the claim itself is fascinating. I mean, I just love history, so I think it's fascinating. Maybe not everybody does, but the actual history going back into the 1700s all the way up into the 1800s about what happened and how that land got taken away is amazing. And particularly what is amazing is that until this land claim, the government of Canada thought that our reserve was what they call a de facto reserve. So there was never any instrument that created it. But I found that instrument, and that instrument came from the province of New Brunswick in 1787 by a surveyor general who came here. And this is 230 years ago. And he drafted this amazing, beautiful survey from the Grand Falls all the way to the St. Lawrence. And when he did that, he came here for a few reasons. But it's amazing because if you took a Google Maps and you sort of put it over top of this guy's survey, you would go, wow, how did he do this 230 years ago? You know, there are no drones or GPS or anything like that. So it's an, you know, looking at some of these documents were amazing works of art. And in that document is how he set aside 4,000 acres for Madawaska. And when you look at it and you read all like the side notes of, you know, according to the Indians, there's a lot of beaver here, and there's all kinds of information that you can find. It's just fascinating and amazing. But surprisingly, this surveyor general of New Brunswick, because Canada wasn't a country, that document is nowhere to be found in the province. It happened to be, a copy happened to be sent to Quebec, the Quebec surveyor general, and it ended up in the National Archives. So if it wasn't for the National Archives, better record keeping, because the province of New Brunswick really stinks at it, we wouldn't have that map. And in fact, unfortunately, all of his field notes were missing, because that would be a fascinating find. And so yeah, so just going through that history was amazing. And what happened when I was an undergrad at UNB, I was majoring in history, and I did an independent study on my reserve, and I came across maps. This was in the early 90s that showed reserve at different sizes. And so I thought, wow, this doesn't make sense. So I dug further, and that's when I realized that this was wrong. This didn't make sense. So when I went to law school and I submitted the claim in 1998, so I did a rudimentary historical report. I was a student, and then a rudimentary legal argument. We sent that off to Canada, and they sat on it for 11 years. And when they gave us an answer, and they came back and said, yeah, we didn't do anything wrong because there was never a reserve there. So I'm on a reserve right now. If there was, when did it happen? And so that was their legal argument. So we ended up in front of the specific claims tribunal, because so say me and Val have an argument about something, and then I say, okay, here, Val, here's all the documents. This is how you're wrong. And I give it to Val, and Val looks at it and says, yeah, I didn't do nothing wrong. So that's clearly not fair, right? So this is why they created the specific claims tribunal. Even though it is government run, it does have a bit of an arm's length component to it. So 5 years at the tribunal. So the very first thing that happened when we brought our claim to the tribunal, the government tried to get me off the file. They said, oh, no, you can't work on this file. You used to work for us, and you would have had access to our justice opinions. which I had been working there 10 years previously. You know, it'd be pretty sad if they didn't update their legal opinions, but whatever. They tried to get me off with a motion that failed. And then they tried to not allow me to use updated legal arguments because, oh, well, the minister didn't have a chance to make a decision on that. And I'm like, so I don't get to benefit from the change in law over the past like 12 years that you sat on my claim? They lost that argument. Then they didn't want me to do new research because or expand the scope of my claim because the minister didn't have a chance to look at that. But they failed in that aspect too. So you know, I was able to do this. 5 years, and we finally won the claim. And the decision is an amazing one. It's great history. It's a great story. Yeah, and then of course the settlement was done within a 3-year period, on and off inside the tribunal because Canada just was really dragging their feet. And of course, there was an election in the middle of our negotiations, and then COVID happened, and very quickly, they finally, this happened quite quickly because in November of 2020, we received a letter of offer to settle the claim. And so one of the things is, even though we lost 3,000 acres, 1,000 of those acres are in Madawaska, Maine, on the international border, and they didn't want to deal with that. So we said, okay, fine, well, I'll go after that another day. So really what we did is we negotiated for a loss of 2,000 acres on the Canadian side. And in exchange, which was pretty much all of downtown Edmundston. So it was the whole city of Edmundston. And in an exchange, they decided to award us 145 million plus they're going to add 1,935 acres to reserve. And that becomes an obligation that they have to fulfill. So that was a specific claim. And that took almost over 25 years from start to finish when you take into account the research part of it. And that's the sort of times we live in when it comes to claims. So title claims, or even any particular fight you have with the government, these things take forever. So our title claim right now is, it only started because we only filed that in October. So we've got decades ahead of us. We've got decades of research, and right now, I can at least speak for the Wolastoqey. Our relationship with the province is not at the greatest. We find ourselves constantly going to court, even just to determine and contractual interpretation things. And so right now we're in a huge battle with this particular government issuing notices to terminate our tax revenue sharing agreements, and that's a big concern because we will now need to sort of strategize how we're going to just start asserting our own jurisdiction on reserve. So I know I'm a bit all over the place, but I'm sure people there have some questions maybe on some of those things. If not, I could feel free to give you some more history on the claim. But if anybody has any questions.